Hi, everyone. Today I'm going to talk about the takeaways from the latest SEC enforcement actions on crypto asset space. I know, among the audience, it's not just lawyers. There are contributors, developers, engineers, people interested in the space, investors, anyone, really. So I want to make sure this presentation is nothing dry and too lawyerly. Hopefully you can all walk away with something useful and something for you to keep in mind. Obviously, the latest US regulatory landscape is on everyone's mind. So with that, very briefly about myself, my name is Chen. I'm an attorney at DLxLaw. We are a boutique law firm focusing exclusively on blockchain Web3 matters. I personally have a background from general corporate and M&A matters. I guess like many of you here, I decided to pivot into Web3 because it's very interesting, exciting, and here we are all looking at this together. Quick legal disclaimer, the information here is very general information only and is not intended to be legal advice, and there is no attorney-client privilege relationship being formed by accessing this material. So when we talk about SEC jurisdiction, SEC only has jurisdiction over any activities, matters, companies if there is a security at issue. Looking back at all of the cases brought by the SEC, there are really two categories of cases. One is brought against issuers. Those are what we know, those actions against Ripple Labs, against Terraform Labs, and early on from against Telegram and Kik. And the question was simple. Was there a Section 5 violation that the issuer entity, which is the labs entity, that had a securities offering unregistered in violation of the Securities Act? Later on, more recently, mostly last year, SEC initiated a few actions against intermediaries. Those are not the issuer entities, but rather exchanges in the crypto asset space, as I'm sure you're aware, against Coinbase, Binance, Kraken, and those platforms. So the key question underlying both categories are what are the securities at issue? Are the crypto assets themselves securities? And or is something else? Is there some other securities transaction going on, and whether SEC has a jurisdiction over these matters? So with that, we can unpack the first category of cases first. The first category are those what we call issuer actions. Those, if since you're sitting here, I'm sure you are familiar. There is a very well-known test called the Howey test, where there are 4 prongs. It's the investment of money, common enterprise, rely on efforts of others, and expectation of profits. The courts over the past 76 years really have been applying that test to many different kinds of fundraising activities. It is generally true that a company that sells something to raise money in order to build out a platform, some projects, is conducting a securities offering. That has been the case over the past 75 years. It's not new to crypto. It's not unique to crypto. And that's what we see in Telegram, in Kik. The court in those cases applied the investment contract test to the underlying transaction, and decided that, okay, Telegram and Kik in those cases violated securities law. That's also true for library, which was more recent last year. And as of that was July last year, we all know that there was a decision issued in Ripple that the court took a more nuanced approach. It looked at the XRP sales by Ripple Labs, not by doing a more nuanced approach by splitting them into 3 different categories of transactions. Number 1 is the institutional sales by Ripple. And those type of sales were really not that different from any other fundraising activities we see in the past. That's consistent with Telegram, consistent with Kik, and was found to be violating Securities Act. The second category, called programmatic sales. It was anonymous programmatic sales of crypto asset, in this case XRP, on different exchanges. Those transactions are blind bid-ask transactions in a very deep and active trading market. And the court considered various factors and concluded that buyers of XRP on those trading platforms do not intend to fund the business of Ripple. They don't know who are buying the tokens from, they don't know where the funds are going to, and they come to the conclusion, and the court come to the conclusion that there is no violation of the Securities Act. And the last category is the other distribution of XRP tokens to employees and third parties. So this is I would not say innovative, but at least very different approach taken in Ripple Labs versus the earlier cases. However, very soon in the same court, a different judge in Terraform Labs rejected that approach. He was very clear and he declined to analyze different types of transactions or draw any distinction between different manners and sales of these assets. Instead, Judge Rakoff in the case was very clear, saying that transactions in which UST, Luna, and some other crypto assets were investment contracts, and so the crypto assets were securities. I think so. Unfortunately, there is no clarity by the court at this point on this issue, and that leaves open the question: are the fungible tokens themselves security? In the Ripple case, it was clear XRP as a token is not in itself an investment contract. While in Terraform Labs, the judge also was clear, saying that because transactions in which UST, Luna were investment contracts, those assets themselves were securities. So that's where we are on the first category of SEC actions against issuers. The open question is very fundamental and instrumental to the second category of cases, which are enforcement actions brought against exchanges. As probably everyone here knows, SEC already initiated actions against Coinbase, Binance, and Kraken, and settled with Breachex. As an example for Coinbase, they charged Coinbase with operating its crypto asset trading platform as an unregistered national securities exchange, broker, and clearing agency. In the complaint, they alleged that 12 tokens listed on the exchange were securities, and each of these charges really turned on the question whether the crypto asset themselves were security, independent of any fundraising activities. There is no issuer entity involved here, or the crypto assets securities themselves. Very recently, that was in last month, in January, during oral arguments, the SEC staff did concede on that point by indicating that a given asset may not be a security, but there is an unclear, undefined ecosystem ongoing that constitutes an investment contract and the security. We will see if the court in the case agree and whether it buys this argument, agrees or disagrees. But that said, there are these few different actions are currently ongoing in different circuits. That means the different circuits may not agree on the very same question, and if they don't, we still do not have any clarity, unfortunately. Along the same lines, that as of last week, a plaintiff, which is a project called LegitX, which has developed its own crypto asset trading platform called Legit Exchange, initiated an action against SEC seeking injunctive relief from the court that they don't need to register with SEC as a exchange, broker, or clearing agency. That's the exact opposite position that SEC is taking in the Coinbase case, Binance case, and Kraken case. This plaintiff strategically chose a different circuit. So we now have the same legal issue being actively litigated in 4 different circuits, and we will see if any if these courts agree on this very same issue. A few other issues was actively litigated in the case or was actually presented in the exchange cases are one of them, the first one, staking. The SEC charged Coinbase for failing to register the offer and sale of crypto asset staking platform. As you may know, as I said earlier, the Howey test is a four-pronged test. SEC alleged that the staking as a service program meets all four tests, all four prongs, and thus was an unregistered securities offering. The second one is a Coinbase wallet. The SEC alleged that Coinbase operated as an unregistered broker by offering its wallet application. We will see, of course, it turns on the same issue, whether the crypto asset that users are able to trade by using the Coinbase wallet or themselves security. If not, then SEC has no jurisdiction, it's no securities law violation. And last one is a stablecoin. That one is a little surprising to many people because SEC here alleged that BUSD, the stablecoin, was offered and sold as an investment contract and therefore a security. It's important to note that BUSD was offered and sold with a variety of different factors ongoing. They were very heavily marketed for its profit-generating, profit-making opportunities. It was very heavily touted by various APYs, yield, different programs that allow users to earn passive income. These factors are unique to BUSD. We will see if the court comes to any conclusion whether BUSD itself is a security and or the offerings of BUSD as a totality of circumstance is a securities offerings. So with that, there are two categories of cases currently ongoing, right? One is those against issuer. Unfortunately, and it's not very clear, as I just said, the current status. Judge Torres in the District of New York in the Ripple case took a very nuanced approach. She analyzed different types of transactions and applied a Howey test to different types of transactions of XRP sales. While Judge Rakoff in the same district court took a different approach. He considered all of the sales of UST, of Luna, different tokens as a whole, and come to a conclusion that, all right, they are securities offerings and the securities. Just as a background, the SEC is currently is expected to appeal to the Second Circuit. We will see what the appellate court comes to conclusion, and until it arrives at the level of Supreme Court, we will not have a final say we won't have a final say from the court what's the status or what's the correct approach of Howey analysis. And in the second category of intermediaries, as I said earlier, it really turns on the question whether crypto asset themselves, whether XRP or a different crypto asset is itself a security. These cases right now, because they're being actively litigated in different circuits, any decision in one circuit is not binding on cases in another circuit. So also same thing, until we arrive at the Supreme Court level, it's unclear and it's remains to be seen what's the latest landscape, what's the latest status of the law on this issue. So I know that this does not leave anyone here with a lot of clarity. I understand that. So with that, I think as a lawyer, a lot of projects, clients, non-clients come to us and ask the question, how can I be compliant? I want to, we are developing some cool project as in the Web3 space. We want to be compliant and we don't want to get SEC attention. I think it's important, with that, it's a piece of advice, not legal advice, but more like a piece of general informational for your advice is to really focus on what's the project's building, what's the mission of the project, what's the goal of the project, and not be distracted by the price of token. We understand the crypto token is a many times a fundamental part of what many projects are building. And we want to advance the technology, and we understand that is part of it. But at the same time, some unnecessary attention can be drawn if there is some very aggressive marketing focusing on crypto asset token price. We know what regulators do not like is seeing that a retail user who does not understand anything about blockchain or crypto invest some money because there is very heavy marketing, very aggressive promotion with some rocket ship emojis on their tweets, and end up losing their money. That's what they don't want to see, and I'm sure that's many of you here do not want to happen either. So really, when you are doing the marketing, when you're doing the promotion, think about what's the goal of the project, and really stay true to yourself what we're trying to do here, and what's beneficial for the community, for the people who are interested in the technology. With that, I know this setting is not very great for questions, but at the same time, I want to tell you that I will stay here for for some time, and we can, if you have any questions, I'm happy to answer, discuss. Also, this is my contact information. Feel free to email me. We always want to know what people are building and get to understand or learn what's the latest in the space and really learn from each other. So with that, thank you very much. Thank you.